afternoon and welcome to the anchor leg of the Transactional Law Relay. We appreciate those of you who have stayed, and we'll try and make this interesting for you. You might be a little nervous because even our moderator cut out early on us. Having perhaps looked at the materials, I'm not sure. So if we wander off into the weeds, you're welcome to bring us back as the moderator will. I'm going to get us started. I'm Mark Fagan, and I co-teach a class with Tamar Frankel at BU Law School. And the topic is securitization. The way in which we've come together to do this is to try and make real a vision that we both had, that in teaching law, you also want to think about the interdisciplinary aspects of a course. And nothing is probably more exemplar of that than securitization, because it touches so many aspects of law, but it's such a core business and public policy issue as well. We spent quite a bit of time wrestling with how to teach it. Do you teach it in a processed fashion? Do you teach it by legal topic? Do you take just examples and unbundle them? After much debate and discussion, we actually went with the linear path, with the process path. And so what we do is we take our borrower and we introduce the students to the borrower, and then we show them how the originator of the loan fits in, how they take and create an SPV, and the SPV in turn takes the assets and turns them into securities. And so what we do is we walk through this process, we explain how the assets are moving one direction, the cash in the other, and then the repayment. On the surface, this seems quite straightforward. I mean, basically, we're taking these illiquid assets and turning them into tradable securities. But when you unbundle it, you find a first level of complexity. Because in addition to our traditional players, many of whom they've already had some exposure to, we get our additional players, the rating agencies, the appraisers, the security brokers, the servicers, which layer on a very interesting kind of dynamic into this process, because they're actually not part of the core process. They're either service providers above and below. To get the students revved up as to why they should be here and thinking about this, we overlay what types of law will the class be dealing with. And so as you look across from contract to property to a lot of securities regulation to tax, when it comes to the rating agencies, the Advisors Act, we've got true sale and bankruptcy. So securitization really touches lots and lots of different places. It in fact makes this somewhat of a unique course to teach, because it isn't as if it is a full course on a core subject. It's touching lots of different. Actually, the core is really the business transaction, because without that business transaction, none of this takes place. I represent the business transaction, Tamar represents the law. So for just as an example, when we talk about, for example, in true sale, my job is to have the students understand risk. Why does this transaction represent risk? What's the investor's perspective as they look at this deal? Why would they be willing to buy one of these securities? A mortgage-backed security as an example. What would be their limitations? What would be their hesitations? And Tamar then takes us and actually explains the bankruptcy law aspects as to how you mitigate that risk by actually having a true sale. So we're, I think, somewhat unique in the ability to have that dialogue, but that's how we go about teaching the class. Because it doesn't form a specific focus area of law, and it is really business, and you need a lot of contextual information, what we've done is we've taken each basic building block and for each created some context materials. They're typically business-style case studies as well as some role plays that allow the students to understand, oh, I understand why an investor would have an interest in these securities, or I understand why the banking industry had an incentive to want to securitize these loans. And then tomorrow we'll come in and actually give the law as well. So that's how we walk through this. What I thought would be interesting to do is to take you through one of the cases. It's towards the end of the book, and it starts to, in the course, and it starts to deal with the financial crisis. Now, we happen to be at a very interesting time, because post the financial crisis, securitization is highly known to lots of people, wasn't probably 5 years ago, and is generally viewed in a negative context, certainly from the general media context that the students are exposed to. What we try and do is get them to think a little bit about, well, how does securitization actually play? And so we've talked, as we've gone through the course, the role it's played in mortgage-backed securities, how violations of both ethics and law by appraisers, rating agencies, etc., have caused all this. But at the end we come back and say, well, what role does securitization have as we move forward out of the crisis? Does it play a role there? And the example we focus on is the term asset loan facility. This is an issue that came up. It was initiated by the Fed in New York, and it was a way to try and get securitization to actually help us get out of the ditch we've been in. The context for it, and in the packet you'll have, that's about 3 pages or 4 pages of description associated with it, and then some discussion questions, which is typically how we try and drive these. But in this particular case, you can see up on the board, this happens to be just asset-backed securities, and you can see the rapid growth and then the plummet in 2007, 2008. If I showed you 2009, it would be equally troubling. But I stop in 2008 because here is where the Federal Reserve is looking and starting to get nervous. Why would they be nervous? What is the problem with asset-backed securities dropping? And this is a mirror image for residential mortgage-backed securities or student loans or any of the other items that can securitize. Well, what's the concern here? We can make this interactive. There's so few of us. What makes it interesting? What would make you the Fed? What would make you nervous?
Well, you know, people tend to throw the baby out with the bathwater. Securitization was a great tool for asset liability management on balance sheets of banks. And they're not using this technique. How are they addressing the mismatch of maturity on their balance sheet?
Great example. What else?
What's selling?
What's selling? And the way in which you can see both of the points that you just raised is if we look at the LIBOR spread. This is the LIBOR spread, and for the eye chart people in the back, it starts in September 2006 and goes up to March 2008. And certainly during the crisis, those spreads are astronomical in the context of finance. And so the Fed is looking at this and saying, liquidity. How are we going to get people to buy cars if they can't get loans? How are we going to get them to buy houses if you can't get loans? And if you have this much concern about liquidity in the marketplace, we're not going to get ourselves back on track. And so they come up with an idea. And their idea is, we need to get securitization back in place. Because, as a matter of fact, that movement in the credit markets, there isn't anything else right now. That is how, for 20 plus years now, we've really generated the movement, the velocity of credit in our finance system. So they come up with the term asset loan facility, and this is an image that I stole it shamelessly from the Wall Street Journal. And here's the concept. The idea is, well, we got to get those people buying cars again, but we can't get them to buy cars because they can't get loans. So how will we solve that problem? The Fed will step in and provide funds to investors, not to borrowers, to investors, to invest in asset-backed securities. Let that sink in for a minute. So your tax dollars, hard at work, are paying for some investor out there, could be offshore, well, it actually can't be offshore, it has to be domestic, And that person goes to the New York Fed, takes out a fairly sizable amount of money. The increments were a minimum of 10 million. You could go up from there. They actually had a bit more, several $billion in facility. And what you do is you pay LIBOR plus, and it's a relatively small increment. So basically, it's almost free money to you. And the only hit you take is, for those of you familiar with a haircut, you take a haircut to provide, to assure the credit worthiness. So it's essentially creating a pool so that if any defaults take place, the government isn't left holding the bag. And the idea was, again, if we can get investors comfortable in this market and get securitization moving again, then all of a sudden we get the economy rolling. They put it in place. They put it in place with an 18-month time horizon, and at the end of the 18 months, it did actually end. It was viewed as being a modest success. You can read that as probably not terribly successful. And the issues around it are why, well, part of it is the economy started to come back. Those spreads I showed you on LIBOR, actually by dint of the economy starting to get back on its feet, started to improve. What we found interesting about this, though, was that it was really a demonstration to the students who are now pretty skeptical about securitization, saying, why did I just invest all this time and money in this class? To see that this is something that is here to stay. It isn't going to go away because, as you're saying, this is how we generate liquidity in the system. In terms of using this, again, trying to make it very topical, very timely, this is an example in the course where we really focus on public policy issues. So this isn't about the law. We're not working on, well, where did the Fed get the authority to be able to do this? This is about public policy. What is the role of the government in trying to stimulate private investors in the securitization process? Those kinds of issues we try and engage because one of our objectives in the course is really to make sure when the student walks out of the class, they understand the business context for why these transactions are taking place. They understand the public policy rationale for securitization, and they've learned enough law, as Tamar says, to make sure, A, you know the right questions to ask, and B, you know which experts to seek out in some of these very special areas.
That's all.
Exactly. So that's how we've gone about trying to teach this basic transaction, make it interdisciplinary, use cases and simulations wherever possible, and recognize that there are lots of pieces of law and that those pieces, A, they need to have exposure to, and B, need to know to get some expertise. So Tamar, do you want to talk just for a minute about, or you have
really
several minutes to talk about how we play this out?
Okay. When you look at securitization, you find that it includes almost the entire curriculum of a law school. It starts with contract.
Here, I'll get back for you.
No, it's okay. In contract, the parties have a right to agree on anything that is legal, and it's nobody's business. And they can do it in any which way they want, and so long as they are more or less understand what they are doing and more or less the same balance, that's the end of the story. But then you move to the product, and the product is property. That's a different story. In property, you must have standardization, and therefore only 12 to 13 forms of property are permissible, otherwise it's against public policy, if I remember correctly, the first year. And information, you're naked. You must tell the people what this is all about. So you have not merely a transformation of the, you have a transformation of the public policy which underlies contract and that which underlies property that wants to create a market. And in order to create a market, you need an entirely different rule. Now, in the middle, you have another funny creature, which is an investment company, or a bank, if you will, because the SPV buys loans and issues securities. That is similar to a mutual fund, with one exception, that if the Investment Company Act would apply, it won't work. So the SEC has given a very extensive but conditional exemption to the SPVs. So when I'm going back to teaching, students have to know something about the Investment Company Act and something about the rule that exempts. Once you do that, you find, and here I must say mea culpa, I was at the SEC, I was on loan for a year and a half when this exemption was given, and there was a thought about everything, I thought, because the main thing was to make a very good distinction between these SPVs and investment companies, so that the managers of investment companies will not use the SPV to get rid of the regulation. What was exempt, however, was a section which only a group of people know, 12b(1), which prohibits a fund or fund or fund or fund. In the 1940s, that is what was done by, as a matter of fact, surprise, surprise, Goldman Sachs. Yes? So they had it done, and they shaved off 1, 2, 3, 4. And so that was prohibited with very little permission by that section, but it was not covered, and the exemption covered SPVs. What happened next? You had an SPV of an SPV of an SPV of an SPV. At the end, you didn't know what you had, and as a matter of fact, you had nothing, because what was taken into these SPVs was not merely an entire value of the portfolio, but the most risky part of the portfolio. So you have that, and you have to explain it. Then you have also Article 9 in order to explain that the transfer is binding between the bank or whoever produced these mortgages and the SPV. But the problem is that in reality, this transfer is not complete, because the transferor permits, sometimes gives assurances, does all sorts of things, so that the umbilical cord is not completely eliminated, and you have a problem there too. And finally, you have also a little bit of bankruptcy and securities regulation. So how does one teach this melange of I will now add another confession. I wrote a treatise on securitization at the time when very few people were interested in that. It was published first in 1991, and the second, but it was so interesting to me, I didn't care if somebody read it or not, so long as I got it out of my system. So what I did was to, in 2006, there's a second edition. I said to myself, students will never see a teaching book after they practice. Whoever saw that in a library, with a case and then questions and so on? So why don't they get such a feel for a treatise? Because that's what they do find in the library. To some extent I was right, but to some extent I was wrong. And because, not only because the students are used to another type of teaching book, but also because it was too much summary and too many footnotes. I eliminated a lot of the footnotes, but a treatise is a research tool and not a teaching tool. And it hit me when I started to try and teach all these subjects together. So what I'm doing now is I will add a supplement, either within the book or outside, doesn't really matter, in which much of the law will be presented also, not only in this form, but also in the form of some cases, some questions, more questions, and more analysis. But it will be in the stratosphere because there's no other way. What they will have to understand is the classifications. And so whether they take it now or don't take it now, UCC, Article 9, or bankruptcy, they will know they have, and that's what Mark told you, they will know to whom to go, and they will know more or less what questions to ask. And at the outset, that's what I tell them. So don't think for a moment you're experts in this, you're not. Nonetheless, I think after students worked at it, it is a catching subject because you see so much and because there's so much now at stake. We end up, and that is really, we end up by asking them. So last year we asked them, would you invest in these things? And you know, we thought we told them how good it is, how good it can be, 90.9. I don't know if there was one. They said, no way, I'm not going to invest in this. Well, this year was a little better. I think they came around because, one last thing, and then I'll stop. Everybody focuses on these mortgages. But the truth is that you have a lot of use for other financial assets to be securitized for the better. And maybe Mark, give us two examples. The first one, yes, and the last one that you mentioned.
Well, I'll actually give slightly different examples, but to give you a flavor for how it's being used elsewhere. Next week I'm off to Spain and doing some teaching, and there's a person over there who is working on securitizing transportation infrastructure. And it has become quite, it is now being viewed as a key tool to fund and finance infrastructure in Europe. And the second example is in China, where initially it was done for non-performing loans, because the Chinese banks, when World Trade came in, had to get rid of all those non-performing loans. They're now looking at it, just as we have, as a way to improve liquidity. So it's become global, introduces a whole new set of legal issues as it becomes cross-border, and that's an exciting area. So hopefully we give you a flavor for why this is an upper-level course. It's a transaction, and it deals with everything you want in law. And with that, we'll hand it over to our colleagues to keep going. Thanks. All right, just a second here.
Tricky mouse.
It is.
Uh-oh. I just want to launch my slide.
Hey.
Okay, hi, I'm Eric Gouvin. I'm also here on this coveted last slot on Saturday afternoon. Thank you.
For those of you who have stayed, when you walk out, there is an ice cream cart with Haagen-Dazs. So there is a reward.
See, that should have been on the program, though. Anyway, when I submitted my proposal, I just said
At the last minute.
At the last minute, actually after the last minute, I said I just want to share what I'm doing in my secure transactions class, and I called the session using transactions to teach secure transactions. So I'm contributing to your course by providing those little loans in the first place. They get bundled together. But this is such a bread and butter topic that it's really essential that someone take it seriously in the law school. And my first point is, it's hard to do that because it suffers from the Rodney Dangerfield syndrome. I don't get no respect. I don't get no respect from my faculty colleagues who think that only when you're considering metaphysical concepts in con law are you really doing law professor work. And from the students who think, oh, here's the book. You know, I know there's forms involved, there's this big statute, all the answers must be there, how hard can this be? When in fact, this is really, for lawyers, for business lawyers, one of the places the rubber meets the road. You have to be extremely competent in working with drafting and documenting the transaction, working with a complicated statute, and understanding not only just the law, but the business side. So I think this is a really great course, and I love teaching this course. But I know there's some challenges involved in it. The second thing is knowing your audience. This is a topic that's on the bar in a lot of places. So if you have a classroom full of students who are taking it for that reason, you have to have a different set of tricks in your bag of tricks than if you have a true upper level elective class. Now over the last few years, I've got to admit I've been stacking the deck. And the first couple classes are spent telling them what a hard class this is going to be and how this is not for people who want to take the bar, and trying to get it to 20 or below so we can really delve into the material that I'm going to show you. If you have too big a class and you try to go to the level of depth and expertise that I want to hit, you're not going to get good and balanced. If you're long tenured like me, that might not matter that much. But obviously, oh, am I being taped? That's not good.
I'm in control. Talk to me.
Because obviously you have different levels of sophistication, interest, appreciation, and apprehension. One of the things that creates all those bad things, the apprehension, is the students going into this thing pretty much blind. They come to law school, what do they know about anything that lawyers do? They might have a gut level sense about torts because they've watched midday TV and they know that you can get rich quick by that. But secure transactions, do they have any context? And that's what I'm really focusing on in this talk, is how to create an environment in my classroom where the students can feel like they're gaining expertise by participating in a transaction, not quite a simulation, but a richly contextual set of teaching materials to bring them along, to make the code make sense. Now, if you're going to do this, here are some thoughts that I had about what you ought to consider. First, be realistic. Be realistic about what you can really do in the class. Now, can you bring in a super high level, I mean, am I going to bring in like securitization issues and the UCC issues that go along with that? No, for two reasons. One, I don't know that much about that. And second, my students at Western New England College School of Law in Springfield, Mass., this is how many people in my class are going to do that in practice. Almost all of my students in practice will help a small business client close a regular old commercial loan at the retail level. I'm going to focus on that because that's what they're going to actually do. Very few of them will worry at night about how to perfect a security interest in intellectual property in Malaysia. I'm not going to spend time on that either. But I am going to help make sure that they know the difference between the rules that apply to PMSIs and inventory versus equipment. Okay, be realistic about the situations you put the class in. I use these materials as an overlay on top of the Whaley casebook, and some of you may be familiar with that. Doug Whaley has, I think, a nice set of teaching materials that are geared to small problems. And the problems are great to zero in on a specific provision in the code. The facts are very whimsical sometimes, and that's good and bad. But they're not very realistic sometimes either. And sometimes it's just so plain what the issue is, the student doesn't really have the experience in trying to figure out what should I be worried about. And that's what I want to simulate here. Okay, so make sure your students know what you're trying to do, because they may get overwhelmed, as you'll see in a minute. I'm going to give them a file that's not too different from a file that a new associate might see. It'll be simplified somewhat, and it's been tweaked so I can create some teachable moments, but they might get a little psyched out if you don't let them in on why you're doing it. And why am I doing it? I'm doing it because I want to make sure that they read the documents. And I want to make sure that they read the code and apply it to the facts and the documentation that they have in front of them. I know from experience that if you just assign the documents, they won't read them.
That's right.
They'll say they did, but they won't. If you do it this way, where the discussion in class really keys off of these materials, you're more likely, especially with that motivated small section, to get what you want. Okay. Having said that, be prepared to do a little hand-holding, because students will get a little psyched out. Numbers will be involved, and that's not always their strong suit. Okay, strategies for bar classes. If you do find that you're not going to have this wonderful upper-level elective, you're going to have to think of a way to still get across the same objectives. Make it personal. Car loans, I find to be the best way to get them to see a bread and butter transaction. Now, these are not perfect, because the way you perfect a car loan is different than what we're mostly going to be talking about in the class, but we do talk about titling. The other thing that psychs students out is when you start bringing in the business terms, and I always do, but business is really jargony. And we'll be comfortable throwing around the code words, but some of the students who were, poli-sci majors or English majors are going to get flipped out if you start talking about liquidity or, any number of business things. I always take a little time out to just make them appreciate that usually these concepts aren't very hard to grasp. It's just that you have to do a vocabulary lesson to get them in your own vocabulary. Because it's unavoidable. You're not going to be able to do this class, you're not going to be able to do a lot of things if you don't have at least a basic sense of why the deal makes money, who's making money at it. Because no one litigates these cases on the basis of principle, although they may for principal. For the big classes, I try to keep it conceptual. So I would be unlikely to bring in financial statements. I'd expect them to do much of anything with them. If we're going to talk about financial documents, that'll all be at the view from 30,000 feet. Okay, if you have this true upper level elective where you have that self-selected group, you're more likely to pull off something that's more fun for you and more enriching for them. Beware, you're still going to have a few bar prep people in there, and you may have some people who just need to take a class that meets at 2:30 on Mondays and Wednesdays. Those folks aren't fun to teach either, but they're along for the ride. With this group, you can now go a little deeper into the business ideas. You're going to see in my packet, they've reproduced quite a bit of my materials in the handout. I do give some sample financial statements for this hypothetical company. With the upper level elective, I feel more comfortable putting in financial covenants in the documentation. And then we'll see later on when terrible things happen to this company, which is always the case in a secure transactions course, that the poor highlighted company is going to face financial difficulties of truly terrible dimensions. We can see if that works out. Okay. But I'm a true believer in this kind of course of doing most of the instruction through problems and simulations. I've spent very little time on the cases. The cases in the Whaley book and the cases that I assign subsequently are mostly there to illustrate a point, to see how a judge applied the code in a situation, and more likely how a judge screwed it up, and get the students to appreciate why this judge, who is a very smart person, a very capable person, but was probably a tort lawyer in practice before ascending to the bench, didn't get the UCC principle that was at issue here, even with the help of his very bright, recently third-year law students who are now. Part of it is a little joking, but one of the things I want them to appreciate that the lawyer does, the commercial litigator in particular, is the commercial litigator is a teacher. And this is no small task when you're trying to get across some points to a judge who certainly learned probably the old version of Article 9, maybe wasn't always a great UCC student to begin with. The other thing about the problems is it's hard to BS your way through it when we're talking about a particular set of relevant provisions in the code and concrete facts that are on the table. I bring in guest lecturers in this class in several situations. First, because I want them to appreciate the business context in which this loan originates. I bring in the banker's perspective. Some of the assigned readings are from MBA texts on commercial banking, like the loan underwriting process. Then I have a friend who's a commercial banker come in and write up this loan and write a term sheet for this loan that we talk about in class. And what were the issues that he thought about, given the various menu of collateral available to him, what attracted him to some and repelled him from others. You're going to see in a second that my hypothetical company that I'm going to talk about today is in the business of oyster farming. Is that inventory that's really going to do you much good if you're in a default situation?
Only if you're hungry.
Talk about threatens to speedily decline in value. That's sort of the poster child for that idea. But anyway, this last point here. I also happen to work with financial statements a little bit. I bring in a local bankruptcy judge to come in and talk about what happens when this deal ends up in his court. I bring in, at the end of the semester, a lawyer from downtown to talk about how these transactions are actually closed and the dynamics between borrower's counsel, lender's counsel. We develop a closing agenda. But I also, whenever I'm bringing in the non-legal stuff, I remind them of what your role as a lawyer is, which is not to do this stuff, but to be conversant enough so you can interact with the people who are doing it, with the accountant, with the banker, or other non-legal consultants who get involved in the process. Okay. Now, in both big classes and small classes, there might be some mini lectures that you need to just get out on the table. Because there are some topics that, in my humble opinion, aren't worth teasing out of the cases or even creating a problem for. So I am not averse to just giving a short and sweet explication of how some things work, like the difference between a sale of accounts versus using accounts as collateral. On a very, very simplified level, getting them to appreciate that here's Farmer Brown, he's owed money by these big supermarket chains, they're good for it, they will pay him eventually, but he needs money now to get his crop in the ground. He can go and sell those three $10,000 accounts receivable to Night Flyer Finance, but they're going to have to take a discount. So this is an opportunity to talk about risk premiums and things like that. Or he could go to the bank and borrow $30,000, but the bank is going to want interest, and they may take a discount too. So oversimplified. This is not trying to get them prepared to go out and do this kind of work, but to get lawyers with math phobia to appreciate it may be that these two different structures really achieve the same financial result or something very similar. And it wasn't that hard to make the leap because of that stupid clip art. Now, these folks are very, the folks that you're sitting in your class are very sophisticated. And if you're going to do this kind of work, the PowerPoint stuff, you've either got to get stuff that's really good or really crappy. So I find that sometimes just using the really cheesy clip art is a good way to get them kind of on your side. Okay, what about leases versus buying a copy machine? Okay, buy this copy machine on credit, give the seller a security interest in the copy machine. You're paying interest over 5 years, total amount $6,500. What if you just leased it? And then at the end of year 5, paid $1. Okay, again, these are things that to you and I, this is so much part of our mental vocabulary, our conceptual understanding of the world. We don't even think twice about it. But the big challenge for me has always been unpacking that, because those 2Ls and 3Ls sitting in my class, this is brand new and somewhat scary stuff for them. So making it plain like this is helpful. So that's to sort of set them up. That's to get them invited to the party. But then what I've been experimenting through over the last few years is immersing them in something that is not oversimplified, something that's actually a fair approximation of a routine commercial loan. And I did that because I was dissatisfied with all the staccato, specifically focused Whaley problems that were just a little too acontextual. And because I wanted to appreciate how important it is to know what the client does, what the borrower does, and to what the lawyer does. And so I've developed what I call sort of a language lab approach. That the UCC is like a foreign language, is what I tell them. And that if they want to master it, just like learning a foreign language, you got to speak it. Because just learning about it, hearing other people give you how you say this phrase and such, is not the same as actually trying to articulate that phrase yourself. And so this is the chance to do that. I also find that some of the students come in with very warped perspectives about what business people are like, what bankers are like. They have these stereotypical notions of all businesses being bad guys, or conversely nowadays, that the rugged entrepreneur who does everything on her own and should be put on a pedestal and sung to the skies. Between those two, I try to develop more realistic images of what business people are like. It develops an empathy because the students are actually in the midst of this transactions. Because they're in the midst of the transactions, it's easier for them to kind of make the leap to think, oh my gosh, I will be doing this in a relatively short time, and I better take it seriously. Forces the documents and the statutes to be digested, and it keeps the class from being too formulaic. That after you've taught the same book a number of times, you know what's coming in. But with this, it's a little bit more leeway. As we're talking about a particular issue, the students are going to have different takes on it, and I think there's a little more room for a different path. But I'm lying, because in the end it is sort of formula. It's all theater, and at least in my class I try to think of this as a production. I know how I want it to turn out, and I want them to get to that moment, but think that they got there uniquely in a way that no one ever got there before, and that they reached this epiphany on their own. And then when I'm on my game, I think that works. Sometimes it doesn't. Okay, so how do I do this? Here's my hypothetical client, Fruit de Mer. It's a company that's engaged in the business of growing oysters in an aquacultural operation. And I really give the backstory on this company. You'll see in the materials, and I'll show you a few slides here. There's a website for the company that tells how they do this, what products they produce. It turns out they produce fresh oysters, of course. They process some of the oysters into oyster sauce, gourmet oyster sauce, for sale at high-end gourmet food stores. And every now and then, there's pearls in the oysters. So why do I do that? Well, if you've taught secure transactions before, you know one of the problems is classifying the collateral. And so as these oysters are coming out of the sea, they are farm products. The students will always think that they're inventory. That's a big problem if someone has an interest in inventory and others on farm products. Right? Once we start applying some manufacturing processes to these raw oysters, they morph from being farm products into being inventory, and so forth. So this gives you an opportunity to sort of test that sort of thing. And then the initial package has all kinds of things like where on the earth is this place, some existing financing relationships that are already in place, a mortgage with a local bank. Turns out they also have a deposit account with that bank. Equipment leases, specification sheets for a boat. Why a boat? Well, they're on the ocean. Turns out that boats might be subject to an alternative federal recording scheme, the Federal Ship Mortgage Act. So let me just show you through some of these things. This is the part of the website for the company. It really gets them to appreciate the richness of this business. And why does that matter? Well, there's been a number of people today already who have talked about the importance of asking about what the client does. It's something that seems obvious if you've actually been a business lawyer, but it often gets lost in the classroom. These are not interchangeable widgets. Each business has its own backstory, and what they're going to be doing with the collateral might affect how you lawyer this transaction. And so this is, and I told Tina I didn't want this going too far because I don't have rights in the intellect. I just crib these pictures from various places. So I never thought that I'd be publishing them. So if there's any IP lawyers here, please cut me some slack. I think it's fair use within the context of my course. But they are beautiful pictures, aren't they? Here they are actually harvesting the oysters. Here is the town I grew up in on the Connecticut shore. It turns out it's also the home base of Fruit de Mer. One of my colleagues lives actually right here. Why does this matter? There's going to be some fixtures issues that come up in this case. The big process, the big piece of equipment that this company has to grow these oysters are some state-of-the-art stainless steel racks that are anchored in Oyster Cove. And they're held down by these cement blocks that weigh 2 tons each. And the cove is tidal. You can see where I'm going with this. You know, it's like there's a equipment lease. These state-of-the-art racks are leased to the debtor, well, leased to Fruit de Mer by Aquatech Inc. But when you look closely at that lease, gosh, it looks a lot like a security interest. Now what? If we go to foreclose and the mortgagee already owns the property, has a mortgage on the fixtures, are these things fixtures? Are they equipment? It's just a rich opportunity to talk about things more organically, more the way that they really happen in practice. Here's the mortgage. I go down even with these silly like barcodes and stuff, try to make it look like what they'll encounter if they were to go to the registry and do a search, or if they looked online nowadays.
A lot of legalese, Eric.
Equipment lease, again, a great opportunity. One of the nice things about this course is it forces students to really work with statutes. And UCC has this definition of a lease. And the definition really is, it depends on the facts of the situation. That's really the definition. Then they give a bright line situation. If these things happen, you have a security interest, not a lease. The students tend to go to the bright line test and forget that the test really is very open-ended. It's only when you have those specific things that you're in sort of a safe harbor. And so I have a couple of equipment leases at work here. And this isn't just like, Whaley will give you the problem, it's got this attribute, this attribute, this attribute. Is it a lease or is it a security interest? This is like you got to read 3 pages and think about it. Because that's how we really do things in real life. So here's the boat. Here's the specs on the boat. Why does it matter? Ship Mortgage Act. Here's the title on the boat. Titles, what a pain in the butt. Some states have titling statutes for boats, others don't. Turns out this woman who, Diane Mollusky, she's the principal of Fruit de Mer, the oyster farming. Diane Mollusky, get it? She started her business in the nearby state of New Hampshire, and before she moved down to Commercia. And New Hampshire sometimes has a titling statute, sometimes it doesn't. Sometimes Commercia has a titling statute, sometimes it doesn't. Guess what? If the original security interest attached in a state that had issued the title, that's going to govern for as long as that title is good. And it's going to be good until another state issues a title. And this is something that causes students to pull out their hair. But it's more fun to teach this way. If you have actual documents, there's something satisfying to them about touching these things. The gourmet oyster sauce is a high-end item that stores are reluctant to buy as part of their inventory. So how do we distribute it? Through consignment. This is the consignment agreement. It's just basically a letter. Turns out that the way they've actually pulled things off over the years, this one kind of looks like a security interest too, because the longer it takes you to pay for the stuff, the more you have to pay. And if no one has ever actually returned any of this stuff. And then finally, pretty simplified balance sheet. Depending on my gauge of the class, we might go through to talk about some of the assumptions that go into these numbers. Every now and then I'll have an accountant in the class and I'll enlist his or her help with this. But this is going to matter in terms of the discussion about should we lease, should we borrow, the financial covenants that might be in the financing agreement. So, so once I've got this background in place, then it turns out we're going to have a need for additional financing. I bring in my commercial banker friend, he writes up a term sheet, and then we begin the process of documenting the loan. And I try to make it a bread and butter kind of transaction. They need a security agreement, they need a financing statement, and I'm going to talk about that in a second. I can also use this as a launching off point to talk about things like statutory liens. The UCC is not great at dealing with statutory liens. The case books are even worse, because one of the things that you need, if you're going to really talk about this, is a look at the statute. So in this fictional jurisdiction of commercial where all this is taking place, I have a statute for boat liens. I have another statute for mechanics liens, depending on what scenario I'm using. So the students have a short and sweet statute that has problems that I built into it present. Deposit control agreements. I'm going to show you in a second. I have a deposit control agreement, which is going to get into competition between the bank who holds the mortgage on this property. They also are the primary depository institution, but they're going to people who have claims against accounts receivable and proceeds of inventory. Oh, wow, that didn't come out very good. So, security agreement, here's a UCC. Although we do our searches, I bring them online to show them the searches. I give them a classic printed out UCC. Ivana be the governor. She's the Secretary of State. Deposit control agreement. Deposit control agreement's in there because the rules for priority between the bank that maintains the deposit account and someone who's claiming the account as either as proceeds or through control are really persnickety. There's 3 different scenarios depending on how you establish the control. And this allows me to focus in on a particular method, and then we can have a more sophisticated discussion about if the secured party perfected their interest in the depository account through this method, how do they stand up vis-a-vis the bank that maintains the deposit account in a battle for set-off? Then the crowning, the coup de grace is the scenario here can become the test. You can just keep rolling with it, turn it into a hypothetical for the exam. The students now are very familiar with these underlying documents. I give them a few more facts on the last day of class, maybe another document or two. And like I say, it's always something terrible happens to this company. Often something precipitous, because I'm also going to be testing them on preferences. And so, you need all the elements of a preference for it to be an avoidable preference. One of which is the debtor had to be insolvent at the time of the transfer. And we rely usually on the 90-day presumption of insolvency, but it's just a presumption. So if during the 90-day period they started out in good shape, but on day 45, the red tide came and killed all their oysters, or a nor'easter came through and wiped them all out, transfers taken between day 90 and day 45 might actually be non-avoidable as preferences. You can't ask them in a timed 3-hour exam at the end of the semester to go into that. But I don't feel bad asking them on a take-home to think this through, because this is, again, forcing them to read the statute. The magic words in the statute matter, and the facts matter. Match them up. So I give them this on the last day of class, and I give them as much time as they want, basically. I make it due on the last day of the exam period. And I do that because they've got other stuff they've got to take care of, time management they've got to learn how to handle. I don't want to hear any whining about, oh, I had 3 exams in the first week. I don't care. Just get it into me. You have plenty of time. Students who are not good at time management will make a huge mistake and spend all their waking hours for the next 2 weeks working on this problem. I hope that's a lesson learned. Anyhow, so they can really dig in. I can make them use financial statements. Sometimes I have to supplement the record with something like this is general laws of commercial. This is based on the Massachusetts statute about garage keepers. I can give them an abstract from a title company to kind of run the real estate records. I have in the past given them a case on fixtures from our jurisdiction so they can make arguments about that when we're fighting over those racks out in Oyster Cove. Pros and cons, it's a lot of fun. I really enjoy creating this alternate universe, but it's a lot of work. The students, I think, enjoy it. It allows them to synthesize the course in a way that, I've gotten positive feedback from the students that I'm targeting in this class. The students who are just a casual taker of the course, they don't like this very much. The students who really want to master this material, they eat it up. You can see, okay. Sometimes I allow them to work together. Certainly during the semester, I encourage them to collaborate. And sometimes I get really good, insightful observations from study groups. The test, of course, is a test of individual knowledge. The take-home format I always like because I can page them in it and it has to be typed. So, so it's much easier to grade. The downside, sometimes you make mistakes. That's, a lot of the documents I'm putting mistakes in there on purpose because it's going to be my teaching moment. Almost every semester I find there's some other mistake which I'm going to tell them was a teachable moment. But I realized, oh man, I didn't mean that. It really only works best in small enrollment upper level electives. If the students aren't really into the hardcore version of this, it's not going to be as effective. You can import some of this stuff to a larger group, as I tried to set up at the beginning of the course, but to do it the whole 9 yards, it's better for smaller groups. Honor code concerns, if students are working together, every school has a different way of dealing with that. And when I use it for tests, which I have been, every year you got to rework it, right? The core of this hypothetical stays the same from one year to the next, but that last bit, you've got to be creative about finding another good way to put them through the paces, because you can't give them the same exam twice 2 years ago. So that's what I got for you. I really enjoy doing it this way. I have another course. I have another setup of this where it's instead of aquaculture, it's a company that farms maple trees. It taps sap from maple syrup and has a little snack bar and restaurant. Art.
Okay, from secure transactions to entertainment law. I'm trying to think of a really clever transition. I don't actually have one, but actually can't lose.
I think that the mouse is up there.
But interestingly, the principles of teaching are very similar. I hope you'll. All right. I teach 2 courses. One leads to the other. The first course is Negotiating and Drafting Media Industry Transactions. The title of this course was determined by surveying all the courses everyone else teaches and putting a bunch of words together to make it look attractive, honestly. And I say media transactions. I used to teach it in just the movie business, but media is movie. They're all very similar. And because of the way the industry is moving, media is a better word for what we do. But the contracts are all very similar. And the second course I teach is now called a clinic, working with filmmakers. The students who took the first course are allowed to work with low-budget, independent filmmakers. And I'll explain how that leads into one leads to the other. The first course is just like everyone else, has a mix of completely different backgrounds. They're never two alike. There are some students who have been working in a law firm doing entertainment law for years. There are others who have been paralegals. There are some who are LLMs who have passed bar exams. There are some who are second-year law students who have just finished a contracts course. They're all over the place. So like everyone else, I start at some sort of common ground, and for some it's redundant, for some it's not. And I find the students who've had sometimes less background do better because they don't have bad habits, for starters. And like everyone else, they come into my class trying to figure out how to get a good grade, trying to figure out what I want. Their idea of a transaction is filling in the blanks, which I explain to them that's called a paralegal, which is so insulting. It's very funny. You want to insult them. Well, that's what the paralegals do. If you just want me to give you the blanks and you fill them in, be my guest. That's not what we are doing here. And their idea of a transaction is taken from a lot of the court-related classes they've had and the cases they've read. Who wins? Did I get more? Did I trick you into giving me something to make my client happy? So we spend a little bit of time explaining that's not what a transaction is. It's not tricking, and it's probably not winning, especially in entertainment. If you don't have a meeting in the minds of the parties, they're just not going to do it. And if they do it, they're going to drag their feet. It's not going to work, and they're all going to blame you. And if you go to court to fix it, you failed. A good transaction does not end up in court. Even if there's a disagreement, your transaction is supposed to take care of that. And as you know, in entertainment law, you'll have feisty personalities. So our job is to make this work. You have to, as with everybody else's transaction courses, understand your business. So I explain to my students, you may not end up being entertainment lawyers. You may be doing all sorts of different things. I promise you, if you do them in Southern California, you will have an entertainment client, by definition. When your used car dealer client, your big client comes in and his son wants to get the rights to a book to make a short student film, do you want to say, I can't do that? No. My estate planning attorney represents Roger Corman's literary material. How cool is that? Everybody has entertainment clients there, and there are a lot of entertainment-related issues. In addition, the contracts that we work with, a lot of the clauses we focus on apply across the board. That said, you have to understand the business your client is in. What is this client doing? It is not simply the paralegal drafting. It is not simply creating a document. How does it fit? This I created. I don't know if I gave you all copies. If I did, don't attribute them to me. I wanted to explain how media is created and where the lawyer stands. If you are just doing a piece of it, if you are up here doing this one little piece here, you have to know how it relates to the rest of the project. Because if you get it wrong early, the rest fails, even if you're not part of that transaction. You may be coming in on behalf of the other side. If you don't get your piece right, the entire transaction fails. And these can be hundreds of millions of dollars involved, which I'll hopefully get to before we go, how that happens. So what do? We are doing various parts of this process. Lawyers are involved in almost every step here, from the get-go to the end. We start out with acquiring material. Where does media come from? It comes from other media, it comes from an idea, an original writing, it comes from all over the place. And what's the legal issues? What does a lawyer do to acquire those rights to do something? On and on through the process. And we get all the way to the end, believe it or not. They don't believe me either. There are basic underlying laws that apply to media. They apply across the board to all media, and all parties have to focus on these, but their lawyers do. Primarily, their personal rights, your rights to privacy, publicity, defamation, all those rights, and intellectual property rights. They have to be addressed in the contracts, even service contracts. If you are doing if you're the crew, if you're the best boy, whatever they do, you still have intellectual property issues. So we take care of those, make sure that everybody's on the same page with the underlying rights for this industry, as you would with any other industry. And then we spend a lot of time talking about this piece right here, this chain of title. Everybody in this business, in the entertainment business, knows those words are important. It's only us lawyers who knows what they mean, and they all look to us to make sure that's right. And it is right on that chart from the very beginning. Without a proper chain of title, things fall apart all the way through. You will have a beautiful piece of media that you have on your shelf. No one can see it, nobody can touch it. Chain of title is our job. Knowing how to do this is the secret of our success and why they pay us. We go through what precedent contracts are and really take them apart. We look very carefully at what a precedent contract is, and by the end of the class, hopefully they understand it is not a form either. They are simply a record of a previous transaction. We go through what goes into them, what are the standard things, that there's no such thing as actual standard terms, but what kinds of things are generally in them. We go through two sets of deal points. If you're going to do an option purchase agreement, what are the standard sort of things that show up in that deal? So when your client comes in and says, I want to do this, I want to make an option purchase out of this, and after you talk to them, you realize, no, they don't. It's a different deal than they thought it was. We can still document it, but you can't tell them they can't have an option purchase. You need to know what that deal is. And the second would be, what is your deal? What do you want? But most importantly, from the very beginning, we look at contracts. What's in this? By the end of the class, we also go through the process of negotiating. We go through comments, redlining, compromise. And I have students who go off to do jobs who come back and they say, on day one, I knew how to redline, and they've never had an intern before who knew how to redline. No kidding. Imagine wasting your time teaching your law student how to do that. Drafting and negotiating contracts. We talk about how they're formed. We go through examples. We talk about what boilerplate is. And if we have enough time in a particular group, because they're very sophisticated, we take apart some boilerplate. Because it's so easy for lawyers to just sort of race through the old force majeure and choice of law, because, yep, sure enough, there it is. It can make a huge difference. I have find the parties on this list because find the parties is hilarious. if you've worked with students working on contracts, finding the parties is the most fundamental thing, and they so often get it wrong. And I was backed up on this. We went to meet with the lawyer who represented the Beijing Olympic Committee. Fortunately, it was in LA. And if you think about Olympics and intellectual property, the moment it's performed, the moment that first recording is made, there is intellectual property created. The performance itself, on record, is intellectual property. How does that all come together? Who owns what? It can't be anything more complicated. It's very simple. But you have to back up and think about who your parties are. Once you get that straight, everything starts to fall back into place. You tie the contracts together. He explained to my students how to do it, and his first thing he said was, my interns just really have to focus on who the parties are. We go over etiquette in the attorney's role. Everyone today has said deal makers, not deal breakers, but really what does that mean? How do you get from point A to point B and be known for that person and not the one who slowed it down? And you may still have your job, especially if you're in-house, but you'll find that your client is moving around without you. They've actually gone ahead and done the deal. By the time they bring it to you, they bring what we call a wet napkin, and I've seen them. They go off to the Cannes Film Festival and hand you your wet napkin, and there's your deal. You've been cut out of a lot of the process there. So if you are considered the person who makes it happen, great. And various other things that lawyers do in the business to make sure that you are really involved with your client on the proper level. Legal versus business issues and entertainment is huge with new lawyers. They've all watched, Entourage. They all want to party for their clients. They all want to wear the baseball cap and stay out all night. Do that if you like, but at the end of the day, they call the lawyers the suits. We are the suits. Literally, they call us the suits to our faces. We are considered to be the grown-ups in the room, and law students have to understand that or go be an agent. First day of class, I give them this for an in-class exercise. You have copies of this in the materials. It's a certificate of results and proceeds. As you can tell, this was actually handed to me by a client. And you've got the scenario in your materials, which is the true scenario with some variations. Basically, she really was excited about this because our producer just already did the pilot. It's going to be so exciting. We just need to sign this so we can take it to the studios. It's going to be great. And I hand it to my students, and as you read through this, you have 15 minutes, because she can only afford half an hour of your time, so off you go. Read through it, make some notes, meet as a group, 2 groups, and answer what are you going to tell her? You can tell her 5 sentences. And she wants to know if she should sign it. We go through it in class. First I ask them, the group, should she sign it or not? Mostly yes, she should sign it. Because after reading this, they realize what the client really wants is fame and fortune, like all of our clients. And there seems to be some fame and fortune going on here. They're going to make a movie out of her thing. She's poor. It's going to be great. How bad can it be? And then they go through and make some comments. The first thing looks like a lot of legal stuff that seems pretty official. What should we do with it? Oh no, they fiddle with it a little bit. At the end of the day, this is just fine. As creepy as it might look to them, and they really start to tear it apart. All this legal stuff is a work for hire under the Copyright Act. This is real standard stuff. Of course you have to have this in every contract. Droit moral sounds Frenchy, and moral rights of authors are being waived here. Oh, well, you can't waive your moral rights. What? You must always waive your moral rights. In American contracts for entertainment law, we always waive our moral rights for reasons we get into later in the class. But at this point, the students' eyeballs are rolling back. Reps, warranties, and indemnification. They play with that a little bit. They do it usually wrong. For example, this is, in the facts, this is, your client is a co-writer. She mentions there's a co-writer. Well, that means she can't rep or warrant anything because there's 2 people involved in writing this. She doesn't own these rights. It's not her stuff. There's 2 people. But at the end of the day, this is a real standard clause. As with the rest of them. They're all pretty standard stuff and, some pluses and minuses. So most of their comments are irrelevant and wrong. These are pretty good clauses. Should she sign it? You don't tell your client to sign, even in entertainment law. That's really the moral of this story. Don't give your client what they want just because they say they want it, and entertainment clients want everything. They want you to make all the decisions for them. That is a business decision. Entertainment makes it very difficult for that because they become very dependent. Unlike some of your sophisticated clients who are not, they know exactly what's going on. Ours tend to hand it over to you. No, you do not tell her to sign this contract. That is what malpractice insurance is for. You give her all the pluses and minuses. And some really clever students occasionally notice there's no consideration here anywhere. She doesn't get fame or fortune out of this. With all this fancy stuff, there's no fame or fortune. It's a gift. She's given her materials away. Why does it look like this? And why did I end up with this from a client? Because what happens is the other side has some really important documents that some lawyer had drafted and cut and paste together the law stuff that they knew was essential. That's what this is. There is such a thing called certificate of results and proceeds, or you can call it anything you like. These are real clauses from real contracts shoved together to look like something she was going to sign, and probably did, by the way. And so that's their introduction to first day. I collect this. I take it all back. Why? So it isn't their precedent folder. They don't someday pull this out and say, "Oh, look at that cool stuff, let's use it," when they forgot what was wrong with it. So I collect this. But we've begun the exercise now to get their attention. This is what lawyers do. This is the kind of stuff that shows up. What are you going to do? And how are you going to handle this? I then go through a number of other exercises of varying degrees of complexity. For each one, I have them create a client file. The theory being, I am then looking at something that they understand to be the transaction. Each transaction has a separate client file produced by every lawyer involved. For that transaction, it has to have your research material, your notes, the drafts, emails, whatever happened, just like a real lawyer would do in a real client file. If they don't do it, I mark them way down. If I can't tell where this transaction came from your file in a vacuum, as if you had vanished. In a real law firm, if you don't show up tomorrow, somebody has to take your client file. I have them do that. And that answers a little bit of the what's the writing requirement that goes into this. They write a lot. The first, after this little fake thing we do in class, they do an option purchase agreement. If you remember on the chart, that's where they acquire rights. Have them acquire rights to underlying material. And we go through a variety of other transactions of increasing complexity. The first one, I just give them the stuff. Here's the client file. It's got a memo in it, it's got the notes of meetings, off you go. By the end, I bring in actors, student actors, hand them their reality. You are a writer or you are a producer. Actors are fabulous because they actually don't think beyond what they're handed. If you do it with students or with other faculty, they can't help but help a little. Like, don't you want to ask me about this? Well, maybe not. You don't get any of that from an actor. You just get complete vacuum. And I explain to them, because they are in the business, that you are to act that role. Did anybody see Tom Cruise in Tropic Thunder? Okay.
Yes.
All right. He's doing somebody we all know. We know who he's pretending to be. That's hilarious. Actors get this. So they act the role. The actor client, I give them pictures of their dogs and cats. I give them pictures of their cars they want to buy, the other roles they've done. And they are, because actors do, they're welcome to wander off and talk about their pets and their pet projects and whatever it is. And the lawyer's job in this last transaction is to bring them in and get the information. You've only got 20 minutes. They do it in teams so they can learn from each other doing it. But if you didn't get the info, good luck with that, because now they're gone. They went to visit their guru in Tibet, just so you know they're gone, which happens. And the producer clients come in for the same thing. They have information and they answer the questions. And unless the lawyers at this time pursue the answers, which are there, but they aren't going to give them up. If they don't pursue them, good luck with drafting, because the other side has information you don't from the same set of facts, because they pursued it. Fascinating to watch that develop. The last transaction, they get through all the way to the final deal. They're forced to cut a deal. That includes the emails, includes letters to clients, it includes meeting with each other if necessary, but documenting that, memos to file. You don't just meet, you have memos to file. Final letter to the client, final delivery letter to the opposing counsel. And these meetings with the actors at the end, at this point they've done a variety of them, they're hilarious to watch. At this point they tend to get the client's name. Once they didn't. The actor said, that's just my pseudonym. It's my stage name. They write it down, and there it comes in the contract with a stage name on it. Okay, not a person. And I do all my work through my company. If you don't ask the name of the company and then actually go to the Secretary of State's office, most actors are making up what a company is. They don't know they're supposed to actually create one. They just think it sounds good to have a company. They've got to pursue it. That's what we do. That's our business. When the producer client says, I'm sure I'm going to get that money because my dad promised it to me and he's rich, that's a condition precedent. You don't have the money, Don't just draft a contract you can't fulfill. You don't have money. It's a condition precedent. So all that comes into play in the last one. And they really do get intensely involved because they have, these are real clients coming in as far as they're concerned. Some of the actors are really good. They actually think they're real. Then we take some of these clauses and start to play with them. And I like to, as much as possible, to bring in reality stuff from showbiz because it's really fun to talk about. Sorry guys, but it's really, these things are just in the news and they're interesting. And it's law. Many of the things you read about that involving entertainment, it's our fault or our responsibility. And here's an example. Recently, there's something called a changed elements clause that goes with the turnaround. Turnaround means I give it to you, and under some circumstances, you can get it back. Generally, it means I did nothing with it. So if a turnaround clause is there, I gave you my script, and you didn't develop it. After 3 years under turnaround, I get it back. But good lawyers, there's all sorts of other stuff that goes with it. I don't just get it back. I have to pay you back your development costs, and all sorts of things happen. All this goes on. I only have a period of time. All that's what we do. And there's something called changed elements. Changed elements is equivalent to a right of first refusal. It means I have the right to take this. I got it from your studio had it. 2 years you didn't do anything. I get it back under turnaround. I get to run around town trying to get somebody else to buy it, and you get your development costs back. But if they change something about it, anything, the actor, the director, the script, budget, I have to take it back to number one because they might want to do it. Now, if you understand your business, at this point, hopefully they do a bit, why would that happen? It's a silly kind of thing. Why would you want it back? You just rejected it. Because in this business, your worst humiliation is something you rejected makes them rich. I rejected Harry Potter is not something someone wants to be known for. So when Warner's interested in it, you want to bring it back. What are they going to do with it? That's why some of these projects float around for a long time. Most of them do. So that's a changed elements clause. Very common in the business and very popular. Project Runway. What happened? Remember it was off the air for a year? This is why. It was a very interesting thing that if you do case law for these courses, like I teach it, it doesn't work. There was no case law to find out how this turned out. There were lawsuits filed, and it got settled like everything else gets settled in this business. We rarely litigate because it's too expensive. What happened is the Weinstein Company had Project Runway at NBC Universal. The principals of the Weinstein Company weren't getting along with the principals of NBC Universal, which has a long history. And decided they wanted to move it over, and they had a 5-year deal with NBC. Then they got another 5-year deal and a $150 million offer, which they accepted, and a $20 million advance. If you paid attention to the business, you knew that Weinstein was a little hungry at the moment. $20 million was good money. And the day they announced the deal is the day NBC sued. The same day. They sued the same day. Under right of first refusal, changed elements turnaround. There it is. What was it? It's because when they took it over to the next studio, they didn't come back to NBC and say, I have a better offer. Now do you want to meet it? And here's the defense. Lawyers actually did this on paper. The defense was, oh, but wait. I told NBC Universal that the offer we're talking about is so huge and stupid that you'd be insane to try and match it. That was their defense, that I told you that. It was so huge and stupid. That's what it says in the filings. So for a year, they're back and forth on this. The judge grants a temporary restraining order after 8 months. This isn't going anywhere. The $20 million has been banked. Everyone's countersuing everybody else. And go figure, they settle. What have we learned? So huge and stupid is not a proper application of right of first refusal. Does that mean that this client isn't going to do it again? It's Harvey Weinstein, just so you know. Yes, he's going to do it again. Has he learned his lesson? No, he hasn't. So if you're his lawyer and you know this business, you're going to keep an eye on this sort of event. If nothing else, write a note, this wasn't my idea, I told you not to do this, something, so you're at least covering your client for this sort of event. That was a very expensive clause. Very expensive clause. Now, Harvey Weinstein gets sued often. You can look him up, sued pretty much all the time, and there's a lot of money involved here, but that $20 million was earning interest for Harvey that whole time, and he probably was just fine with this result. Where are we on this one? Right of first refusal is Watchmen. This is me taking this out of some various publications. This wasn't in a lawsuit like this or anything else. I kind of pieced it together from information I had. But again, know your business. Remember Watchmen, everybody knows about that. Big deal, big deal. The scenario for Watchmen, if your client's going to work on it, here's what happened. In 1986, the comic book came out, huge hit. Everybody wanted to make it, but technology couldn't make it. There wasn't enough technology to make this thing work. I remember it. But Fox gets the rights early on. They hire a producer. The guy's name is Gordon. Hire a producer. They can't make it. Producer, they say, actually he was president, they fire him, he takes this and some other rights with him, and they say, fine, see what you can do with it. Under turnaround, they keep distribution and a share of the film's sequel profits. They give it to him in turnaround. They want their development costs and interest back. They later claim changed elements. I haven't seen the paperwork, but let's say probably. Producer rushes it over to Universal. Same project, he's got a draft script. Off he goes to Universal. Universal looks it over, hires a writer to do it. I guess he didn't have a draft yet, does a draft. That's great. Off he goes, and it sits there, and it sits there. Universal does nothing. He walks it over to Paramount. Paramount pays Universal 10% of the development costs. Turn around, feel it, there's your turnaround, and agrees to pay the 90% addition when it's made. Has turnaround occurred? Oops. At Paramount, they have a change in ownership, same people who are still there, who immediately fires everybody. Fox later says, this little bit down here, that they find during discovery, but an internal email at Fox saying it's a stupid script. That's the defense Warner's got. Warner takes the film from Paramount, because everybody got fired there, gets the director. Remember, Warner's made the picture. Paramount says it at this point weighs reimbursement of its development costs to co-finance. Remember, Paramount was last to have it. Warner says, clever us lawyers. Warner says, oh no, wait, you didn't have the rights to sell us. They're not yours anyway because you never paid the turnaround 90%. You don't get your rights back. Haha, you never had them in the first place. You're out of the loop. Paramount sues. Warner settles, gives Paramount 25% ownership plus foreign distribution. For what rights? To make the suit go away. Now, how do you explain that? Because that's the way the business works. Fox then knocks on the door. He says, by the way, nobody's got the rights but us. Because under changed elements, we haven't got this, and you've changed elements. Which is where Warner comes back and says, we found an email saying you didn't like the script. Nice try. Judge laughs him up, says no. Remember what they were making the picture at this point. It was in production. The judge says, nothing on the face of the complaint of the documents establishes the producer ever had any rights in Watchmen. It's Fox's. Warner's has just about wrapped production on the picture. Isn't that special? How much are we talking about? Warner Brothers, Fox settled. Fox got $1.5 million development costs, 8.5%, now I think it's a sliding percentage, of box office receipts, and all sequels and spin-offs. There goes the tent pole. This isn't going to be Spider-Man for these people. So Warner has a co-producer on this. Some of the money that comes in from day one goes to their partner, Legendary Films. From what they get, they have to pay Paramount Pictures 25% of their share. Paramount gets foreign distribution, and Warner's gets up to 8.5%. And if it's box office gross, that means from first dollar. So what have we learned about changed elements? Not going to stop the executives from doing this, but as lawyers, somebody didn't catch the chain of title problem at Warner's. General counsel's switched since then. And they now have a chain of title department they didn't have before this. True, at Warner Brothers. But if this is your industry, like any industry you're in, if you don't know that's going on and you just step right into the project, how can you possibly do a good job? You've got to get the whole dynamics going. You've got to see how this fits. You've got to know that chain of title back to 1986 counts, as somebody at Fox sure did. You've got to know it all matters. And just for laughs, we go through the numbers. These are very rough. It cost $150 million. At the point it was settled, Warner's had $150 million into this. Box office gross, last I checked, was 177 million domestic and foreign, but remember, that doesn't go to Warner's. It goes all over the place before it gets to them. You call break even at 2.5% of your budget. So when they go, yay, we broke even, because it's not just making the thing, it's the cost of advertising it, making prints, all the other costs are wrapped in. So until you make 2.5 times 150 million, you have not even broken even. From Warner's point of view, 2.5 times the budget to be success, no chance. There won't be a sequel under these terms. So if you're the lawyer that points that out, they may yell at you, but at least you're covered and you're not fired. And the best lawyers in town worked on this. That's all the studios. Every studio that was anybody has had something to do with this. So what happens next? What have we learned? We learned that chain of title, that they expect the lawyers to be looking at it, and they're just going to run out and do their deals. We know the importance of turnaround, changed elements, these little clauses you see every day make all the difference. And we know what an entertainment lawyer is supposed to be doing in these. Oh, and more importantly, we know the importance of malpractice insurance, because the producer is who, Warner's went after the producer. Shortly after this, they had to have their quarterly meeting with their shareholders. They have to explain what just happened with a $150 million investment. There was no Harry Potter that quarter. They had to explain what just happened. So what did they do? They blamed the producer, this little guy named Gordon. It was his fault, he lied, we counted on him, he signed the documents, we blamed him. So who does Gordon blame? You know the answer. So his lawyer has gone through his malpractice deductible already. The firm is in big trouble. He went after his own lawyer. That's who took the heat. In the press and everywhere else. So cover yourselves in entertainment and everywhere. Working with filmmakers is, we're calling it a clinic now. It's something I made up because it seemed like a good idea, and it's a nice extension from the other class. What we do is we take all that we've learned and then move it into, let's try doing it. They've looked at most of the contracts. They know the underlying principles. They kind of get the biz. And we help ultra-low budget independent feature filmmakers. They're not hard to find in LA. I screen them to make sure that they're real. They're fully funded pictures with start dates that are set. And we do all of their work for them. We set up their corporations, or they're mostly an LLC. We will do acquisition of underlying rights. We do the copyright filings. We do all the contracts for everybody involved, all the release agreements. There's very little we don't do. But they have to be fully funded. And many of them film while we're in class. And for them, we do a nice booklet. I think I brought one with me with all the contracts. Each filmmaker gets one of these, which they can't believe their luck because these people have no money. But we give them a booklet with all their contracts in it and explanations that go with them, so that they can actually see what they've got from us. It's not just a bunch of emails that they'll screw up. And the advantage for the students is they get to do the entire process. These go pretty fast. They're all done by the time we're done with the class. Nothing's going to hang out, otherwise I have to do it, so it's all finished. But they get to see the entire process of making a piece of media. Movies and internet's all the same thing, same document. So they do the entire, from day one, except for the financing of these. And really feel the timelines, how key they are. I'll let the class pick if they're going to work on something or not, but they do, they got to finish it, because no one's allowed to graduate unless they finish it. No, I'm stuck with it. We had one we worked on last spring, which just was at the Newport Beach Film Festival, which is a very fast turnaround, and won Best U.S. Picture at the Newport Beach Film Festival, which is close to where we are. So a bunch of the students were on the red carpet, and they went to the after parties. I didn't tell them that's not what lawyers usually get to do. But it's a nice way for them to see the entire transactional process in a business. And they get a credit on the film, and they get to beef up their resumes, which is pretty sweet. And they then have writing samples to take with them to interviews. It's a contract they actually wrote for a real piece. We have releases from everyone to use this stuff. And they work with outside counsel. So it's a nice lead-in from the other that you can actually feel the process of doing these. And we're out of time.
Well, thank you.